I've got more important things.
Hi, everybody. We're going to get started with the third session. For those of you who are just joining us, my name is Diane Hernandez. I'm the Editor-in-Chief of Tulsa Law Review. And it's my privilege at this time to introduce the moderator for our third panel of speakers today, Professor Melissa Luttrell. Professor Luttrell joins the University of Tulsa College of Law after 2 years as a visiting assistant professor of law at Florida International University. Prior to entering academia, she was in private practice in Los Angeles, where her work included representing hospitals in complex civil litigation in state and federal court. Earlier in her career, she served as legislative counsel for regulatory affairs at Public Citizens Congress Watch. Her scholarship considers the appropriate use of microeconomic principles in legal decisions that relate to environmental and public health risk regulation, the ways that decision makers actually use available evidence in the absence of perfect information, and the integration of idealistic notions of what protective environmental and public health laws can and should do with the pragmatic realities of the world that actually exist. So, with that, please join me in welcoming Professor Melissa Luttrell.
Great. Well, it's now my pleasure to introduce Professor Richman, who is also a professor of law at Duke University School of Law. He earned his bachelor's degree from Brown University. He then studied biblical and Talmudic studies in Jerusalem. He earned his master's and his PhD from UCal Berkeley, and he earned his JD 90 cum laude from Harvard Law. Prior to entering law school, his activities included serving as a visiting lecturer in economics in Hanoi. He also worked for the International Trade Committee of the U.S. Senate Committee on Finance for several years. After law school, he clerked for Judge Selya on the United States Court of Appeals for the First Circuit. And he has also an unbelievably impressive set of publications that are pretty amazing. So with that, welcome Professor Richman.
Thank you for the generous introduction, although if I would admire, I'd like to at least equal the threshold set by the PTO, where 5% of what I do actually has a consequence. That was a very generous introduction. To fill in the biographical information, I was a student of Einer's at Harvard, have been a mentee of Einer's, a long-time admirer of Einer's, and a lot of my work, I should scratch that. All of my work fills one of the many subcategories of work that Einer has. Einer does lots of stuff that I don't do, but all the stuff that I do, he does. And in that sense, his work, at least a subsection of his work, has been enormously influential. And what I'd like to talk about today is one area of his work that actually does not have any exclusive connection to the healthcare system, but has a lot of implications for the healthcare system. Einer has been recognized in addition to being a moral philosopher, in addition to doing constitutional work, in addition to doing lots of work in the healthcare system, also is one of the nation's leading scholars in antitrust law. And recently, very recently, Einer has taken on what in many respects is kind of I won't say it's but he's taken on the establishment in fighting a fight that really has needed to be fought for a long time. This is on the doctrine of time. So, a very brief introduction or background for those who have forgotten their antitrust law. Antitrust, one of the sections of the antitrust law, the Sherman Act, that was passed in 1890, prohibits certain conduct by monopolists. Monopolists that have certain market dominance or market position. There are certain things monopolists cannot do. And one of the things that generally fall in the category of bad monopolist behavior is tying. That is, if a monopolist has monopoly power over one product, they are prohibited under certain circumstances from bundling that, from tying it with another product. The classic example is if a monopolist on a person that has monopoly, a company that has monopoly in the supply of bolts cannot tie nuts. Of course, the two go together, and it would be a problematic tie. There was a reaction to this rule. To a large degree, its roots came out of the Chicago School of Antitrust, which was a very significant revolution starting in the 1970s, that started to apply some more rigorously applying the laws or the logic of economics to antitrust laws. And the critique goes as following: wait a second, I'm not really sure this whole time prohibition is a good idea. After all, there is only one monopoly profit. That is the foundation of the critique. If a monopolist has a monopoly over the supply of bolts, there is nothing to benefit by tying it with nuts that are competitively supplied. The monopolist is not gaining any additional profit. There's only one monopoly profit. If the monopolist only has one monopoly, then tying other goods that are otherwise competitively supplied does not increase that monopoly profit. And therefore, if they are tying, they must be doing it for only good reasons. And there are no anti-competitive consequences, and therefore we should not enforce vigorously, or really at all, the prohibition of tying. This, I think, to some degree had become maybe not the prevailing wisdom, but certainly was a critique of the tying rule that gained a lot of support, a lot of momentum. And some recent, would you agree with that? That essentially the tide has been moving in that direction. And in a very, very significant article in 2009, Einer said, look, there is a misconception that there is only one monopoly profit. Very often there is more than just one monopoly profit, and because of that, when there is tying, there really is competitive harm going on. A monopolist, by tying another good, tying their monopolized good to a good that's otherwise supplied competitively, really is inflicting economic harm on the marketplace and on consumers, and there are a whole bunch of reasons why. The key insight that he had, I think, can be summarized in the following. Yes, a monopolist that monopolist over bolts is not doing any harm by tying it to nuts, but that is the exception. And the rule, actually, is that is the exception to the rule that in general really is problematic. Very rarely do you have a one-to-one product, monopolized product to competitively supplied product tie. More often it's more competitive than that, and in those situations there's real threat for competitive harm. So in that 2009 article and in some recent exchanges, Einer really has been pushing this rule, I think extraordinarily convincingly. It has been met with what I would say is unsubstantiated or inadequately substantiated resistance. So this is an academic debate that is going on right now. It has real implications for the practice of tying law, the practice of antitrust law. And my paper, which is co-authored, and I want to emphasize that in a moment, my paper says, look, there is a lot of this debate really has taken on in the realm of theoretical models, which is extraordinarily important for antitrust law. In large part because looking at empirical efforts to support the utility or the usefulness of one antitrust rule versus an alternative really is a very complicated endeavor. And a lot of antitrust law as far as the legal development theory, what arguments about what the law should be, really happens in the world of economic models and conceptual arguments. This paper looks at a particular industry, the computer industry, which is, I think anyone would recognize, an extraordinarily important industry, and it looks at one company, IBM, which everyone, I think, would recognize an extraordinarily important company in the development of the over the last century of the U.S. economy. And it looks at a series of efforts by the Justice Department to essentially apply the tying rule, prohibit tying to IBM. And my co-author, Steve Usselman, is a business historian. His expertise is he is the historian of IBM. And really, it was this paper was born out of a conversation that I had with Steve when he was visiting Duke. He's telling me about his research. I said, your history, 100 years of maybe 80 years of IBM history, really can inform very meaningfully on the policy debate that's going on right now. So what this paper does very simply, is look at certain interventions, certain policy initiatives by the Department of Justice to require IBM to unbundle some of its services, and it looks at the consequences of those interventions. And the paper argues that this is history. We're looking at one case study, an important industry, an important company, but nonetheless, we see that there is extraordinary economic benefits that accrued from the Justice Department in these particular initiatives. So, a little bit of background on IBM. There were 3 antitrust initiatives against IBM, one in the 1930s, one in the 1950s, and then one that began in 1969 and really went through much of the 70s. It ended in a consent decree in 1982. All of these initiatives challenged what really is IBM's foundational business strategy, which is to develop, to supply comprehensive business services. So the IBM strategy, starting really with Thomas Watson Sr. in the 1920s, 1930s, is to provide comprehensive services. They have salespeople going to business clients and say, look, we have a whole bunch of things that can help you. We have computers, we have technology, we have know-how, we have salespeople, we have experts. If you give us a certain fee, we will help you with all of our stuff. It's a one fee for a bundle of services. In the 1930s, incidentally, by the way, Thomas Watson Sr., I say senior because he was succeeded in the company by Thomas Watson Jr. Thomas Watson Sr. Actually went to jail for a while for an antitrust violation before he was actually running IBM. He was very hostile to antitrust interventions and really fought tooth and nail. In the 1930s, the first antitrust intervention by the Department of Justice was with IBM's tying of its accounting machines with its punch cards. So accounting machines back then, they weren't really necessarily computerized, they're mostly mechanical. But they were devices that used punch cards where you entered the punch card in the data, you threw it through the machine, and the machine would process the data for you. So normally you would buy one processor, often you would lease it, and then you would purchase the punch cards individually. And IBM essentially said, look, you have to buy our punch cards if you buy our machine. It's a classic tying. And I think most would argue that this is a tie whose design is to price discriminate. The people who use the machine more would use more punch cards, and therefore the high users, the people who value the machine more, would pay more. There is a debate as to whether this strategy of tying is really a good thing or a bad thing. I will say that I'm unconvinced that the history of this intervention really has a lot of consequence. Maybe Hunter would be able to clarify something on this a little bit. But after the intervention, which essentially prohibited IBM from bundling its accounting machines with its punch cards, required to sell its punch cards separately, or really required it to sell its accounting machines separately, where anybody could buy an accounting machine and then buy punch cards from wherever they wanted. It didn't really reduce IBM's market share. In fact, IBM's market share grew, in large part because I think the industry grew, accounting services, the demand for accounting services really swelled growing into World War II. But IBM's economic power really was not diminished by the prohibition on its tying. And maybe that means that enforcing the rule doesn't really impose any inefficiencies. Maybe it means that although the criticism on prohibiting or preventing price discrimination is that you reduce output, maybe this is an argument that actually prohibiting really did not reduce output, although it's hard to actually think of what the counter positive would be. But there seems to be very little learned, really, from the imposition of that, or the initiation of that suit in the 1930s. All right, the next are a little more interesting. In the 1950s, the Antitrust Division in the Justice Department, this, by the way, led to a 1956 consent decree, was really scrutinizing IBM's bundling of more sophisticated machines with services. Now, it's pretty clear that IBM, and this is from internal records that Steve Usselman has unearthed, it's pretty clear that IBM was advancing a strategy that is defensible on antitrust grounds, at least. The strategy is this. We want to bundle our software and hardware services, our CPUs, our central processing units, with all these ancillary devices. And the reason is because we want to be really flexible. We want to go to our individual clients and be able to meet their needs with all of our different services. And again, we want to maintain this business strategy of having a one-fee consulting services for everything that our company can offer. This was bundling, of course. It was bundling the CPU unit with a whole bunch of ancillary services. It was also bundling with other hardware services, the CPU with know-how, with repair services, with printers, with other ancillary hardware devices. And the 1956 consent decree required IBM to do the following. First, IBM was required to sell and lease its products and its parts, and to license its patents and technology. So again, previously, everything under IBM's control. And the only way you would be able to get access to IBM know-how was by engaging it as a client. Now, IBM was required to sell and lease its hardware, and everything that came with it. It also, the consent decree also required IBM to set up a new entity. It's a wholly owned subsidiary called the Service Businesses Corporation, SBC. SBC was essentially, you might say, the first unbundling of hardware with something ancillary. The notion of software really hadn't been developed at this point. But SBC was essentially an outlet. It was a service provider that used IBM's products. Even though it was a wholly owned subsidiary, it was a new way of providing IBM services. You would go to SBC, and they would have IBM equipment all around, but you would be purchasing only their services. So really there was a division, a forced division between the hardware and all the services, all the benefit that came out of the hardware. So that was the consent decree in 1956, that IBM, it really restricted the way IBM wanted to market its services, and also it created a little bit of an outlet for another business model. So what happened? SBC grew. It was very desirable for consumers to have the ability only to purchase services as opposed to all the hardware. But it's not clear that SBC's market grew in extraordinary proportion. It's possible that its growth just reflected the business that IBM lost. It's also, another thing that happened also is IBM's business model still seemed to succeed. That is, the tied model, to the degree they still could do this, still seemed to be attractive to a lot of consumers. But there was some other really interesting that was happening. With the development of SBC, IBM also made investments, and SBC also made lots of investments in what was really kind of a new market on programming. There was a sense that developing applications for this hardware, this stuff. There's a lot of things you could do with this stuff. And once people had access to this stuff, there was a market to essentially find out what those new applications are. And IBM recognized that, and SBC recognized that, and there were enormous investments in this emerging new market that really was forced upon the marketplace by the consent decree. IBM invested a lot in new division of programmers, in new data centers, which in many respects kind of competed against SBC, that was offering data processing and other services, other standalone services. But what's really fascinating, and it's very consistent with the theory of why we want to have a vigorous tying law, that is a pro-enforcement one, is the consent decree really allowed the development or the emergence of other business bureaus, other service bureaus. So lots of people saw what SBC was doing and mimicked it. To a large degree, if you just look at what SBC did, that's not really telling you a whole lot. If you look at the whole marketplace, you see a wealth of intermediaries. Some people actually criticize SBC for not erecting market barriers. But there was this whole market that grew of intermediaries, users of IBM hardware technology, and developing a whole bunch of new applications for it. And what's especially important about that is wasn't just a natural outgrowth of dividing it, but it was a function of the emergence of the new market and the ability of new programmers and new users to really invest in understanding what those new possibilities were. So you saw a real injection of dynamism in the market. You saw all sorts of specialization of uses of computer uses, the growth of intermediaries that in turn developed new services markets, new software markets, And to a large degree, you saw a new profession of programmers that really developed out of this consent decree. So, consistent with what Einer's been saying, inconsistent with the single monopoly profit, there are a lot of dynamic innovations, dynamic efficiencies that can come out of enforcing the tying law. And we see a lot of evidence of that in the 1956 decree. The third chapter, the first one is the 1930s of the punch card, and the second one is the services from the hardware. The third one began in 1969, and it was brought by Ramsey Clark on the final day. Ramsey Clark was the Attorney General at the time. On the final day of the Johnson administration, and it was persisted through the Reagan administration. So this was not this I guess had some bipartisan support. And what's interesting about this is that not only was it brought at a very high level, but the chief counsel of IBM was the former Assistant Attorney General from the Antitrust Division. So you had some very smart, very knowledgeable lawyers on both sides really working at the highest levels of antitrust policy. And this was under not Tom Watson Sr., but under Tom Watson Jr. I should have actually mentioned the previous suit was against Tom Watson Jr. also. Tom Watson Jr., much to his father's chagrin, was very collaborative with the Justice Department. He recognized that, look, this is a constraint we really have to work with. To a large degree, that's why Tom Watson Jr. was, for the most part, fairly cooperative in coming up with the consent decree in '56. And through the 13 years of litigation, there was a frequent communication, a conversation going on between the IBM lawyers and the Justice Department lawyers, and trying to figure out a way to essentially avoid mutual destruction. So what was it that the Justice Department was worried about? Well, in the mid-60s, IBM produced its System 360. In many respects, this was the Tom Watson Jr. signature initiative. Some people say that it was one of the most significant business developments, business strategies in America in the last 100 years. It, as much as anything, revolutionized the computer industry in a way that benefited the innovator. So in some sense, it's not just innovation that's uncaptured, but this was really innovation that was captured. The System 360 offered a new possibility for intercompatibility among computers. So there were a whole bunch of things you could do with this same computer. It was a very versatile computer. But because of its versatility, because of its interoperability, it established its own platform, and Justice Department was really worried that that IBM would lock out everybody else on the hardware market. So here's a little bit of an irony. The Justice Department in the 1956 decree, or the investigation, was worried about the development of ancillary markets. That is, IBM was monopolizing the hardware market, had a monopoly of the hardware market, and was tying all the ancillary markets that would not allow the development of the ancillary markets. And the Justice Department was worried about that, and it proved to be right. That, in fact, after the tie, there was an enormous growth in that ancillary market. In the 1960s, late 60s, the Justice Department was worried about the hardware market getting locked in, that no one would be able to break in. So again, there was a demand to unbundle hardware and software. Software, I think, then is a little more of an intuitive idea than for what we have now. And again, it not only unleashed a lot of dynamism in the hardware market, but again, really, even though it wasn't really the Justice Department's intent, it also unleashed a lot of dynamism in the software market. What happened to IBM during these 13 years? Again, this is where the historian really comes in. Steve looked at the internal memos and said, even through this conversation between the IBM lawyers and the Justice Department, because of that conversation, because of pressure from the Justice Department, IBM did change its business strategy. And but for the intervention, but for the tying claim, would not have let go of the software industry as it did. So what happened? There was, again, enormous software development outside IBM walls. There were a lot of what was called S360, System 360 emulators, which allowed other hardware manufacturers, Dell, Wang, to produce hardware, use computers that then use S360 software. So not only did you open up the software business, but this was really what the Department of Justice was really hoping for, it really opened up the hardware business also. And in a very interesting twist that Artie would play, a lot of what came out of this conversation is whether or not we should copyright software, whether software should be subject to the copyright laws. And originally IBM was saying, our concern is only with the hardware market. But then once there was an unbundling, there really was a growth not only of software development, but also of software and intellectual property rights. We see in at least two of these three initiatives enormous economic benefits as a consequence of the antitrust initiatives. Again, the historian analysis is the Department of Justice is worried about certain things that IBM did, worried about certain tying elements, certain bundling practices that IBM was doing. For those reasons, it brought those suits, hoping to unbundle and hoping to open up the markets. And critically, but for those suits, IBM would not have changed business practices. And I guess number 4, and really good things followed. That is the syllogism that we see in these two examples. Steve makes an additional argument, which I don't really buy. He doesn't really buy it either. But that maybe IBM was so convinced that bundling software with hardware was impossible that when it developed the PC in 1982 in Boca Raton, it decided to pursue an open architecture that allowed Microsoft and Intel essentially to capture all the gains. And perhaps, he says, were it not for all of these tying claims the 40 years earlier, maybe IBM would have tried to pursue a closed model, and we wouldn't see the PC boom that we have. I don't think there's evidence for that, but never mind. So let me say, because this is a conference that is focusing to some degree on Einer's contributions to healthcare policy, let me close by saying that this is a significant historical case study. Only a case study, but I think a very significant one that really adds empirical heft to Einer's argument on tying, when there's, I think, very little empirical support on the other side. I think for that reason, it's I think a modest, we don't want to extrapolate, but at least a very significant case study that supports the benefits of really enforcing tying law in the way that Einer suggests. And I think that this lends very significantly to a lot of the work that Einer's done in the healthcare market, the healthcare services. There is a lot of tying going on by monopolists, by provider monopolists who say, look, we have the only surgical center in town, but you have to use all of our primary care doctors, you have to use all of our radiologists if you want to have surgery in this hospital. And frankly, a lot of insurers also really bundle services in ways that don't really benefit consumers. And I think there's a lot of evidence to suggest that tying in the healthcare market really is extremely, and maybe even exceptionally costly. There's evidence that the thing that makes the United States unique in terms of healthcare dollars is our prices. We charge too much. The prices that providers charge are often significant multipliers of other prices, similar prices that in other OECD nations for services that, by all accounts, are of equal quality. And the tying strategies by providers really is an effort to expand the monopoly profit. There, as much as anywhere, there is not a single monopoly. And there, as much as anywhere, the tying efforts among providers especially really is an effort to expand monopoly profits. And it is a real area where there is greater need for tying enforcement. To some degree, a lot of this is implicated with the development of the accountable care organizations, which in many respects is one great big tying strategy. We are seeing the kind of consolidation and tying strategies that really could make the development of the ACOs and the consequence of the Affordable Care Act really costly. But on the other hand, with the exchanges, hopefully with the dynamism of certain insurance products and the entry of new insurers, maybe these purchasers, third-party purchasers, really can arm themselves with tying claims and really try to break up monopolized services. There is a real possibility that a dynamic insurance market using tying claims can bring a lot of dynamism and bring some significant cost down to the healthcare services. So this is an extraordinarily important doctrinal debate, very, very important for antitrust writ large, I think extremely important for health policy, and to the degree that history can help, I am very eager to make sure it helps, because the policy certainly is right. I had one final, here's my one final comment. It's really a question. I can't decide what to make the title of this paper. It's initially Vindicated by History, L. Haig on Tying. Another possibility, of course, is L. Haig on Tying, Vindicated by History. But I'm looking for something a little more dramatic, like, how to break up monopolists. This is the only chance we have.